Okay, I think, shall we get started? I'm going to take that as a yes.
Can. Let's do it.
Ready in Kuala Lumpur? Okay, good morning, everybody, and welcome to this panel discussion on the current trends in sports disputes, hosted by 4-5 Chambers in London. My name is Dr. Leanne O'Leary. I'm a CAS arbitrator and lecturer at Maynooth University in Ireland. And at the outset, I would very much like to thank 4-5 Chambers for the invitation to moderate this panel and for putting the panel together. I'm delighted to introduce three stellar sports lawyers who are all well placed to offer their comments on current trends in sports disputes in London and in Kuala Lumpur. Starting with Rupert Beloff, who is the head of chambers and barrister at 4-5 Rupert's sports law practice encompasses regulatory and disciplinary proceedings, anti-doping, free movement and right to play cases, and safeguarding. Rupert sits as a sports arbitrator, is a member of the editorial board of Law and Sport and the editorial board of the International Sports Law Review, and is a co-author of several leading books in the field. Next, please let me introduce Michael Harwood, a barrister also at 4-5 Chambers, who provides advice and legal representation to athletes, players, teams, and governing bodies on a wide range of sports law issues, including eligibility and selection, anti-doping, safeguarding, governance, and contractual disputes. Michael is a member of the Sport Resolutions Pro Bono panel and regularly acts for individual athletes or players, including recently in anti-doping proceedings where he successfully secured a reduced suspension for a young semi-professional rugby player. Our third speaker is joining us from Kuala Lumpur. Richard Wi is a renowned sports and esports law advocate and managing partner of Richard Wi Chambers, a firm that he has led to numerous accolades, including Best Sports Law Firm at the Malaysia Law Awards. Richard is a sports arbitrator. He co-founded the Sports Law Association of Malaysia, is a regular contributor on sports law matters in the Malaysian media, and he is widely regarded as the esports law pioneer in Malaysia. To explain how the panel will proceed, we'll start the panel discussion hearing the London perspective from Rupert and Michael. Then we will hear from Richard in Kuala Lumpur regarding the current trends in sports disputes in Malaysia, followed by a Q&A session. If you have any questions, I warmly encourage you to write these in the chat function or to ask these in the Q&A section at the end, when you will be able to unmute and put these to the panelists directly. I now invite Rupert and Michael to start the panel discussion by commenting on the current trends in sports disputes in London.
Thank you very much, Leanne, and I'll kick off. And I want to start by looking at the current state of play with regard to resolution of sports disputes from a UK perspective. And it is part of a long-term trend and development of mainly arbitral procedures and processes. And it is fair to say that arbitration is and remains the main way in which sports disputes are resolved. And it is also correct to say that the UK has a particularly well-developed arbitration system or systems for resolving such disputes. And if one looks at the rules of various governing bodies, and I'll take football for an example, the main governing bodies in the UK all have arbitration written into their rules and handbooks. For example, the Premier League has section 10 of its handbook. The English Football League has section 9, and the Football Association handbook has rule K, all of which provide for arbitration as a means of resolving sports disputes. So there is a widespread trend of sports governing bodies providing for arbitration. And that is coupled with what has historically been a general reluctance of courts to involve themselves in sports disputes, except where necessary. And there may be signs of change in that regard, and I think Michael's going to touch on that later. But as things currently stand, most disputes are resolved through arbitration. Now, why is that? Well, the first is there has been a general tendency of governments to regard sports disputes as essentially private rather than public matters. That aligns with the views of the majority of sports governing bodies, who would rather keep control rather than allow government to interfere. And I'll speak briefly about the proposed independent regulator of football in the UK and how that might be changing later. So I mean, so the trend has become well established. And I've touched on this, is also, I think, slightly peculiar in the UK compared to other parts of the world, is how developed arbitration processes are and how they continue to develop. And underpinning all of this, perhaps, is sports resolutions, which is now a long-established independent arbitral body in the UK. It was established back in 1997 in response to the 𝗂𝗂𝗿𝗂𝗍 case, and I won't touch on that today because it's rather old history now rather than recent trends, but go and look it up if you don't know about it. And so it's been established for well over 2 decades now, and it has generally been a growing and very successful body, and particularly in, for example, anti-doping cases, it has a wide remit, and many governing bodies have signed up to it. Its remit, in fact, instead extends beyond the UK. If you look at the recently resolved case, very recently resolved case of Mr. Sinner, the world #1 tennis player, that was resolved under the auspices of sports resolutions through their international panel, which allows international governing bodies to refer matters to them. So, as I say, sports resolutions has been set up for a number of decades now. In many ways, it is a UK reflection, or I hesitate to say copy, but certainly some of the same principles applies, of the Court of Arbitration for Sport, where Leanne sits as an arbitrator. It is a domestic version of that. And it is now commonly regarded across many sports as the main forum for resolving disputes. Alongside that, in recent years, there has, however, been further development of individual sports arbitration processes. And it is worth noting that one of the features of CAS and sport resolutions is they effectively have panels of arbitrators, or closed lists of arbitrators, from whom panels deciding matters are chosen. And in the past, where individual sports provided for arbitration to resolve their disputes, quite often the arbitrations, when an arbitration arose, an arbitrator would have to be appointed, and there was no panel to do so. You just went and found an arbitrator. Either that, or you had bodies of what might be various people called, depending on the sports, stewards or so on, who would conduct the arbitrations themselves. That is now changing, and if one looks, for example, at the Lawn Tennis Association or the Premier League, they now have closed panels of arbitrators, often rather grandly entitled judicial panels nowadays. It seems to be the trend, if anyone's aware of the main tribunal service in the UK, and I'm talking about the public one which sits alongside the courts. All the tribunal judges are now called judges, and that trend seems to have transferred to sports as well. So one has these developing judicial panels. Some are now well established, for example, the Premier League panel, and as I mentioned, the Lawn Tennis Association. Cricket is, for example, at the moment, the ECB is reorganizing its disciplinary panel, so it will run alongside similar lines. And there is an increased professionalism all round. Now, against that trend, and against the trend of arbitration being the means of resolution of sporting matters, one has another trend which may just be beginning, which is increased government or public interference into sport. And as I say, Michael, I think will touch upon recent events involving courts getting involved in sports disputes. Now, it's important, just as an aside, to mention that they always have been involved to a certain degree in commercial matters, which and so on. But the other main development in the UK at the moment is the proposed new independent regulator for football. Now, this is a proposal which was first put forward by the previous Conservative government, was being carried over to the current Labour government, and it generally has widespread support amongst both the footballing community and the public at large. I say generally because it's by no means uncontroversial, and there has been significant criticism of the plans by various Premier League executives and so on. Now, the independent regulator for football isn't going to be an arbitral body in itself, but it will have, the independent regulator will have oversight of many matters which the governing bodies currently deal with themselves. And for example, it's proposed that it will oversee owners and directors tests to ensure that individuals in control of football clubs are fit and proper persons. It will have widespread financial oversight. It will have it will have powers to regulate competition, and it will have powers to ensure that relocations of football clubs and so on are subject to tight rules. Now, although as I said, the regulator itself is an arbitral body, it is clear that in many of those areas, it will be impinging on functions that are currently carried out by the existing governing bodies and their arbitral panels. And I'll just take one example. For example, the owner and directors tests, which the regulator will have accountability for, it is a function which is, in terms of in relation to the Premier League, currently carried out by an offshoot of the Premier League judicial panel called the Independent Oversight Panel. So there'll be effectively a repetition of those functions. Now, some of the criticism of the plans or concerns about the plans have come not only from the Premier League, but also from international organizations. For example, UEFA has expressed concern that this represents potential government interference in the governance of football. And it's undoubtedly the case that if this plan proceeds, which is going to, there will have to be a continued dialogue. And this goes back to the point I was making as to why arbitration has become such an established mechanism in the UK for resolving sports disputes. Because, as I said, governments have typically regarded sports as essentially a private rather than a public matter in this jurisdiction. And equally, governing bodies have been happy with that because they want to keep it within their remit. No, the regulator represents a potentially large or significant departure from that, which, along with various signs that courts may be more willing to become involved in sporting disputes, may in future change the landscape. So, in summary and in essence, the position, I think, in the United Kingdom is one has a well-established and increasingly developing arbitral set of systems and quite sophisticated systems. But at the same time, there are increased signs that the courts and the government are willing to become more involved in the governance of sport than they have been in the past. And it will be interesting to see over the coming years and decades as to how these two competing trends interact with each other, and whether it will fundamentally shift the manner in which sports disputes are resolved in the UK. And I think that's all I'll say for now, and I'll hand on to Michael.
Rupert, thank you. Good morning, everybody. So what I was planning on touching on were some themes or trends that there are three really, and they're very closely related to one another as emerging trends in this area. And of course, none of which is to cut through anything that that Rupert has just said in terms of the preeminence of arbitral proceedings, particularly in this jurisdiction. But there does seem to be, as I think Rupert has rightly touched on, a growing trend for the resolution of sporting disputes through other means. And the three trends, as it were, that I was going to touch on that are very closely linked was, first of all, the resolution of sporting disputes through national and, in particular, international courts, as opposed to specialist arbitral tribunals. The second closely linked theme is about the influence of anti-competition law, in particular, on governance structures in sport, and the way that we are seeing that being litigated with sport as an economic activity. And the third closely linked theme are the emergence of new formats, often called disruptor formats, in sport, and how the emergence of these formats is potentially giving rise to a slightly more litigious environment as different sporting brands or sporting entities seek to protect, as it were, their position in the sporting world. So just touching on this first concept about disputes being resolved through what we call sort of ordinary courts, national and international courts, as Rupert has rightly set out, the traditional and still very common position, most sports, pretty much all sports, founded on a private law, private contract basis. Those contractual agreements will elect to resolve by some sort of mechanism. It's almost always some form of arbitral mechanism. And again, as Rupert's touched on, we've obviously got the 𝗂𝗃, which is a very preeminent example of this, but also domestically through bodies like sports resolutions. And they function and operate still very effectively at doing that across most sporting issues around selection, or as Rupert said, particularly around things like anti-doping, those operate really effectively to deal with those. But there are some recent trends which indicate that certain types of dispute are now finding their way into the judicial system through national and international courts. Now, some of the examples I'm going to touch on in a moment, the really sort of big macro level cases over the last year have been dealt with by the Court of Justice of the European Union. I'll explain in a moment why that is. And they are invariably challenges that are linked to the governance of sport. But before I touch on those, it's also right to say that there are other sort of jurisdictions or areas in which disputes are being litigated or dealt with through other means, and one is in the area of employment-related disputes, issues touching on employment rights. Now, of course, it's been the case that athletes and players and so on have been able to litigate these for as long as these kind of statutory employment rights have existed. So in terms of an emerging trend, it's not necessarily right to say that this is something we've not seen before. But I think it probably is right to say that they're evolving in terms of their scope and breadth, and maybe how common we're seeing these types of things. And one of the reasons I think for that is increasingly, certainly at an elite level anyway, athletes and players have such economic power, as it were, because at an elite level especially, players and athletes are more highly paid probably now than they were at any other time before. But alongside that, there seems to be a suggestion that more of their activities and the things that they can do both within and around the sporting world are being prescribed or regulated, as it were, through their contracts that they either have with their clubs or their teams, and therefore, by extension, the contracts that those teams might have with commercial sponsors, other entities, the particular leagues or sports governing bodies. And so increasingly players are finding that more and more of the things that they do, both within and outside of sport, are being regulated through their employment arrangements. And so I think there's a real potential now to see more and more of these types of disputes being litigated around, for example, unfair dismissal or non-payment of wages. There was a case about that recently to do with the former Manchester City footballer Benjamin Mendy. And then in another area I think we might see increasingly litigated through the sort of employment sphere is around essentially freedom of expression or free speech rights, and how what players and athletes say, either through social media platforms or in interviews, it is impacted by how they are regulated through their employment contracts and so on. So that's one area. There's also the possibility, again, just to touch on something that Rupert mentioned, which is the possibility of regulation through a statutory regulator in sport, either in football, but there's also conversations about that happening in other sporting arenas as well. And that inevitably opens up the question, if you have a regulator that has a statutory footing, whether or not that is amenable to challenge through a public law sphere. Presumably, one would think that any regulator that has a statutory footing could be amenable to something like judicial review. So again, another one to look out for. But what I'm going to do just briefly is come back to something I mentioned a moment ago, which is some of the big, what I call sort of macro level cases that have gone through the Court of Justice on the European Union. And the thread that really ties those together are they are areas in the sporting world where we are seeing rules and regulations or decisions that are being made that touch on that have economic or competition law consequences, and that's why we are seeing them being challenged in front of courts like the CJEU. So the first was a case that was heard, or the decision was handed down in the autumn of last year, and it's a case about the footballer Lassana Diarra, and essentially about some of the transfer rules that operated at the time. He had terminated early his contract with his club, and essentially his case was that he was being penalised from being able to move elsewhere because the rules required the club that was picking up his contract to effectively pay the fine or the sanction that he'd been asked to pay for this early termination. And I won't go into the detail of the judgment because it is pretty lengthy, and you can look it up if you like. But the Court of Justice of the European Union said that certain aspects of the way these rules operated restricted the possible freedom of movement of individual players. And this is a case which is could well have quite wide-ranging consequences for the football transfer system, which is a real sort of economic powerhouse of the game, and the footballing authorities are I'm sure engaged in quite frantic conversations with their own lawyers at the moment to work out how, if at all, they need to maybe rethink some of the ways that these structures are put together just off the back of this particular case. Another one, which well, it's not really one, but it's three decisions which were all handed down together towards in December of 2023, so a little over a year ago. These were three linked cases, linked insofar as they dealt with very similar issues. The European Super League case, which some of you may be familiar with. This was about a sort of the threatened breakaway league by certain elite European football clubs. Another case to do with the International Skating Union, and a further one to do with Royal Antwerp Football Club. Again, I won't go into the detail for want of time, but the threads that linked certainly most of these issues together was the fact that the CJEU felt that because of the sort of economic imperatives that ran through these particular cases, and the possibility that some of the rules that were being engaged in these cases had anti-competitive consequences, essentially. The setting up of new franchises or actions taken to prevent clubs or bodies from setting up new franchises. The sort of anti-competitive consequences really meant that they engaged various EU laws and restrictions, or freedoms, sorry, and that's why they felt that they had to intervene. So it's before just sort of touching on those sort of competition law aspects, there are a couple of points to make about these types of challenge potentially being a bit more commonplace. The first is obviously is an obvious one, which is the sort of movement of sporting disputes increasingly outside of the veil of private proceedings. This obviously means potentially more disputes which are open to the public to observe, to hear, and to understand, both in terms of the sort of substantive legal position, potentially some of the evidence, and so on. It means you get, like we have in these cases, publicly available judgments and decisions, which inevitably is going to increase some degree of transparency and public understanding about what the issues are, what's being litigated, and so on. And it's potentially good for lawyers too, because we get to see and understand what's being argued, and so on. So there's that aspect of it. But secondly, of course, there are consequences for the traditional dispute resolution mechanisms, such as the Court of Arbitration for Sport, and that's a particularly interesting one in the context of the International Skating Union case, because in that particular case, the European Court of Justice expressed concern with the way that the ISU had about its rules on agreed sort of arbitral mechanisms. So this is one where the ISU had elected the Court of Arbitration for Sport as an agreed arbitration dispute mechanism. The CJU said this was potentially problematic because it was potentially asking the CAS to determine EU law issues, which they say in this case were the competition law related issues. And the CJU's view as well, the CJU has to be the final court of appeal for any of these issues, not sort of private independent arbitral bodies. So that adds quite an interesting sort of slant, as it were, onto the way that the increasing prevalence of these kinds of rights and freedoms and things are intruding on the way that sort of sport is being regulated. So yeah, I won't delve too much into the competition law aspects of these cases, because you can sort of read about them yourselves. But in short, what we're seeing as a consequence of these is that where there is viewed to be a clear sort of economic imperative, or an element where that restricts or distorts competition in terms of the way that sports are being run, you can expect there to be a growing role for potentially sort of anti-competition regulators, but also courts, national and international courts. So what's the reason that we're seeing why these challenges are proliferating more and more? Well, this kind of touches on that third theme that I mentioned at the outset, which are new formats, disruptive formats, new governance structures and rules, and not just those coming into play, but how people are responding to them. So when we look at the European Super League, what lay at the heart of that was the sort of traditional governance structures effectively threatening sanctions against any clubs which wanted to participate in a breakaway format. And so you've got these new formats that I think it's pretty clear that these things are going to continue to emerge, because there is an increasing desire to sort of exploit the commercial landscape in sport, capture new audiences. That's a really big part of the rationale for new formats now, particularly pivoting traditional formats towards younger audiences. The idea that they always need to be faster paced, more entertaining, that sort of thing. You're seeing that particularly in things like cricket, which I think is a real potential hotbed for new formats, new tournaments, that sort of thing. And it also reflects a sort of possible changing power shift in sport, in terms of, if we were to look at the European Super League, for example, what lay at the heart of that were a lot of these elite European football clubs saying that they weren't sort of happy with the way things were being done, and they had a better idea. They wanted to go away and set up their own tournament. That's a recent example, but we also have in something like Formula One, as long ago as 2009, there was a threatened breakaway by all the teams in F1 to set up their own new franchise, because they weren't happy with the way that the sport was being run at the time, and the principle that underlined that. And I guess it's probably similar with the breakaway football league as well, as they say, well, you can't you can't have the sport without us. So I think it's a very powerful recognition of the influence and the power that individual teams and to a lesser extent the players and athletes have over the ability for these sports to happen. And then lastly, the thing that's driving a lot of these new disruptive formats are just, there are new actors on the scene, investors, often backed by huge sort of financial power, willing to establish and fund new formats. And that's obviously posing a threat to the sort of traditional more sort of monopolistic style governing bodies. Some sports in the world are more used to it than others. You do have certain sports that have multiple governing bodies who sort of work in relative harmony with one another, but you'll have some that are going to have to increasingly now adapt to this new world where outside actors, potentially with huge financial backing, will come in and say, well, we're not really happy with the way things are being run, so we're going to throw a lot of money behind establishing something else. And that in turn will have consequences because of the sort of hawkishness, as it were, of national and international courts that are going to firstly want to supervise those potentially new disruptive formats, but also make sure that, you know, steps that are being taken by the traditional governing bodies are not restricting competition unfairly or disproportionately. So anywhere where these new formats have impacts on rights, on economic rights or activities, you're going to see more intervention. So that's really touching across some of the ways in which disputes are now falling outside of kind of what of the traditional position, as it were. And it's probably a trend, I think, that we're going to see it increase over the coming years, and it will be for lawyers and governing bodies to try and adapt and change to that kind of that new world. Conscious now that I have been talking for rather a long time, so sorry if I've gone over my a little bit, but I hope that was useful anyway to some of you.
Thanks, Rupert. And Michael, and we can pass over to you, Richard, in Kuala Lumpur.
Hi, thank you. Can you hear me?
We can indeed.
Yeah. All right, cheers. Really good talk from Michael and Rupert. Must first say thank you to 45 Chambers for having me on board, particularly my good friend Aaron, who I met in Malaysia a few months ago, who came up with this webinar. And I think it's a real pleasure for me to be here with Rupert and Michael, and finally get to meet you, Dr. Leanne, after exchanging so many emails. Okay, so for our topic today, we would like to share what's currently happening in Malaysia, particularly in Kuala Lumpur. And I have some slides about what's happening in Thailand and Singapore too. And because the slides is quite voluminous, I will try to compress everything and finish by Malaysian time 5:55. So for those of you in UK, good morning. And for those of you who are Europe, in fact, in Europe, it's good morning, Europe. And those of you in Malaysia, good evening in Malaysia. So here, I just wanted to zoom straight into this slide. This is my 4th page, actually. In these slides, recently, the Asian Football Confederation and AIAC came up with a memorandum of understanding where most of the disputes in AFC will be referred to AIAC. AIAC is Kuala Lumpur's version of our International Arbitration Center, formerly known as KLRCA. They have a dedicated sports law team in AIAC, and in fact, the Sports Law Association of Malaysia, which I co-founded in 2016, the base is at AIAC. And AIAC also recently have their own sports law arbitration rules, which some of the barristers around the world went through the rules and had given our feedback, including me, had given feedback to the rules. So I would encourage sports barristers and counsels across Europe, if you wish to refer any arbitration matters, particularly when you're drafting your sports contracts in your jurisdiction, do consider engaging AIAC as your arbitration center, particularly if the contract refers to an Asian element. So we have had cases in AIAC from all over Asia hearing at AIAC, and they have their own specialized arbitrators. People like me, we have had to undergo a particular sports arbitration course in order to be referred to as a sports arbitrator for AIAC. Of course, we are nowhere near CAS, and I think CAS is always going to be the gold standards for sports arbitration hearing, and AIAC is taking baby steps and of course be inspired by the giants of CAS. Now, if I can now start my slides, one of the few cases that I want to refer to. The first slides. Oh, can I introduce my colleague Samantha, who is sitting right in front of me, and she's now, sorting out the slides. So thank you very much, Sam. So the first slide, the second slide. Okay, sorry, forget about me. Next page. The first case I want to refer to is recently. Next slide, please. Oh, okay. Okay, all right. So the next slide is about recently we had a not really a court conflict, but more of a corporate conflict. Our national badminton player, one of the best players in badminton, before taking part in the Thomas Cup tournament to represent Malaysia, insisted that he wanted to continue wearing the clothing sponsored by 𝗃𝗃𝗍, whereas the Badminton Association of Malaysia was sponsored by Yonex. That matter escalated to the president's office, and in fact the minister was also inquired on this by the press. But in summary, eventually both parties came to an agreement. So for the first time in the history of Malaysia, a professional badminton player was called to represent the national team and was allowed certain compensation, was given certain compensation in order for this player to wear a Malaysian BM branding, which was sponsored by Petronas and Yonex. I think we've seen this in football, particularly recently. There's the French national team, the conflict between sports brands, that seems to be happening here too. So while this matter didn't go to arbitration or in court, but it was quite close to going to court. I know of this case because I was the lawyer who managed to mediate and settle the dispute between the two parties. So we managed to evade litigation here. Next. Okay. The next slide is the non-payment of salary. I see my friends here from the Professional Footballers Association of Malaysia, PFAM. They are very active and they are very vocal to support the rights of the professional footballers, PFAM. And so this is one of the cases involved where some of our players were not paid for playing football. And it went so serious that the High Court of Malaysia actually issued an order to imprison the club owner for failure to adhere to the court order to pay. So it became a contempt issue, and the football club owner was actually arrested for contempt. It was quite hilarious because it's never happened in Malaysia before, but there you go. That was one of the ways to enforce payment. Next. Now, this was a very tragic case. Until now, we are not sure what happened. And this football player, really good football winger, representing the national team, actually had an attack where someone or some person had splashed acid on his face. He's recovering now and he's returning to the professional team. And this matter escalated all the way to the royal house, because in Malaysia, most of our kings are involved in sports, particularly football. And in the state of Selangor, where he is representing Selangor Football Club, the president is the prince of the state, the prince of the royalty of the state. And the prince was pretty upset about this matter. And this matter is now being investigated by the police. And until now, they have not arrested the perpetrator. So this is another one more Malaysian style of current trend disputes. Now this case, this one. This is a very interesting sports case. This is a real proper sports law matter. This is a case of a group of athletes involving, but not really recent. This happened about a few years ago. And in 2023, this matter reached the federal court and it was settled at the federal court 2 years ago. I was the lawyer representing the National Sports Institute in this case. In this case, the athletes were part of a podium program where the high performance athletes were grouped together to represent Malaysia, particularly for Olympics and the Commonwealth Games. And these athletes, Muslifah, her name, and another two other national shooters, they were deselected. They sued the National Sports Institute for the wrongful deselection, but the court, the High Court and the Court of Appeal and the Federal Court upheld, no, sorry, the High Court and the Court of Appeal upheld the deselection and accepted that the way the deselection process took place was legitimate. So it became a very good precedent in Malaysia on how to deselect an athlete properly. Next slide, please. This one is another matter recently involving a Paralympian Olympic, a swimmer. This swimmer was deselected, and he had lodged a complaint, and he wanted to even include the Minister for Sports in order for him to be included. But unfortunately, until the time when the Paralympic event took place in Paris, he still could not get in, and the matter is now at the moment kept in abeyance. I don't think the matter went to court, but it was very close to going to court or going to arbitration to resolve the dispute. Another one more case, the next one. Recently, I think in November or December, the World Badminton Federation released the written decision of this case. In this case, the World Badminton Federation had suspended a former national badminton player for match fixing and betting violation. And the other gentleman who was found guilty also of this is a National Sports Institute performance analyst. This case was held over a space of a year and a half, and it was conducted by BWF. And if you read the decision of the case, it was interesting to see how BWF managed the investigation, the discovery of evidence, and the way the hearing was conducted pursuant to the statutes of BWF. The badminton player was, in my view, not very well represented, and eventually he lost the case, and he could not articulate a reasonable defense to put forward his case. Whereas the National Sports Institute performance analyst took a more admitting state position. He admitted to his wrongdoing and he pleaded mitigation. And his violation was more towards a friendly betting. He insisted that he was just betting in badminton, and eventually he was suspended from badminton participation. So these are the recent current trends for Malaysian sports. I'll just go quickly. About 9 years ago, we had a case where a CAS overturned a FIFA ruling banning a Thai football official for manipulating elections at the Thai FA. This is quite some time ago. And then I think this happened about 20 years ago. The footballer 𝗃𝗃𝗃, a very famous football player in Singapore, was found guilty for match bribery by the Singapore High Court. But this is a very old case. But recently, this is not in the slides. I can share with all of you that in Singapore, about 2 years ago, the Singapore's anti-corruption authority detained a group of esports athletes for match betting and match fixing. And that case, I recall the esports athletes were found guilty and they were banned from the game. And this is another one more matter. This is not really involving sports. A few years ago, there was an anti-corruption case ongoing in the Malaysian government, particularly for an officer in a ministry. But the MECC managed to investigate this, arrested and stopped this bribery matter. Next. This is another case in Singapore where the football official was detained for allegedly bribing in a match. This is about 10 years ago. Now, over here, the next few slides, just 1 or 2 more slides. It's just about, can you go back before? Yeah. It's just to share with you a few stadium disputes, issues in this region. Some are really very unfortunate. But it goes to show the importance of security and safety in sports. So the first incident involving the Kuala Lumpur Football Association Stadium, where the very famous football team JDT went up against 𝗃𝗂𝗍, and unfortunately there was a tempest and flares at the stadium. And recently, very sadly, 135 people perished in an incident in Indonesia for the stadium. So these issues highlight the importance of stadium security and stadium safety. And in this region, most of the sports association, particularly football association, sports security and safety is quite paramount, very, very important matters here. On this note, before I move on to show you a bit of governance in Malaysia, how sports is governed in Malaysia, I want to share that recently the Malaysian government issued out a safe sports code, which is very well received. And the code is meant to regulate the behavior and the ethical conducts of all those involved in sports to stop harassment and toxicity. My next slide. This is all about governance in Malaysia. Right on top of the pyramid is the Ministry of Youth and Sports, a very influential ministry which regulates sports, including sports technology, sports, even sports commissioner's office, and even issues related to sports science are all under the Ministry of Youth and Sports. Next. These are some of the statutes involved in Malaysian sports. And as you can see, we have a sports commissioner in Malaysia, and this person is effectively the policeman of the Malaysian sports. They police the activities and regulate the behaviors of the sports association in Malaysia. Next slide. These are the three major agencies in Malaysia. The Olympic Council of Malaysia, of course, is an independent association, which is the governing body of all sports associations in Malaysia. The OCM, we call them, they will select athletes to represent Malaysia, the Olympics. And this is where a lot of lawyers act for OCM in representing them for corporate matters, sponsorship matters, selection matters, anti-doping, doping matters, all in OCM. Then MSN, the National Sports Council, is a government agency formed way back in the 60s in order to assist the growth of sports in the country. MSN organized tournaments, coaches, train coaches, etc., all over Malaysia. And ISN, the National Sports Institute, is our our governing body for sports technology, sports science, and coaching. A lot of sports science analysts works in National Sports Institute. In fact, they manage some of our premier athletes, including our badminton player legend Lee Chong Wei, our cyclist Azizul, and a few other top athletes in Malaysia are managed by ISN in terms of their health and their sports science data. Next, we have our own anti-doping agency called ADAMAS. At the moment, ADAMAS is they are managed by the sports ministry, but they are already drafting laws in order to create an act of parliament to allow ADAMAS to be an independent agency. But at the moment, ADAMAS, even though they are in a way financed by the Ministry of Youth and Sports, but they really operate independently and they conduct their tests fairly frequently all over Malaysia in all tournaments. So I think that's it with regards to our government's structure. And here with regards to before that, please. With regards to our dispute resolution, you can see that these are the dispute resolution in Malaysia, where we have the Sports Dispute Resolution Committee, we have the courts where they conduct mediation. OCM have their own arbitration, and so does AIAC, which I just mentioned earlier. Next is what I mentioned, the Safe Sports Code. I'm wrapping up my talk, and this was launched 2 years ago. Very, very important code and highly, highly respected. And it actually generally deals with matters on sexual harassment, psychological misconduct, physical misconduct, bullying, and sexual grooming. This was launched by the ministry about 2 years ago. Next one. This is just me putting it here, where this is still quite an issue in Asia, particularly in Southeast Asia, where we do see ambush marketing. So sports lawyers are usually called upon to advise sponsors, medias, event organizers on how to stop ambush marketing. In fact, most of the time, my sports law work is involved in this. Next. Yeah, this is just an example to show you what happened in Duolingo, where they were trying to ambush the tournament, the FIFA World Cup in Qatar. Next. This is another one more, the advertisement issue where it looked like there was a ambush marketing. Next. Image rights, etc., etc. These are all very common sports law issues. I won't go into details. Next. This is overview of sports law in Malaysia. Usually when we teach sports law in the universities in Malaysia, more or less, these are the 4 main areas which we conduct our classes upon, or our seminars and trainings in Malaysia. And I think that's it, isn't it? Okay. All right. So thank you very much. In Mandarin, we'll say 谢谢你. Thank you for your attention. And I return the microphone, so per se, to Dr. Leanne. Can unshare. Thank you.
Thanks, Richard. Thanks for the summary of the current trends in Malaysia. So if I could just summarize for a point of comparison, and also to help with the Q&A that we still have some time for. In London, we've obviously got the use of arbitration, sport resolutions for the dispute resolution, and also the potential impact that the new regulator in football may have. The influence, obviously, directly for those of European law, or the recent European law decisions, their influence, obviously, where regulations have, where you have football clubs, for example, football would be the best example, having to engage with the RSTP and so forth. But of course, the UK being a little bit sheltered in the sense that we are no longer a part of the European Union. So there will still, while it may not be directly binding influence, potentially indirectly through the Competition Act, the national law that we have here. So that would summarise the London position. And as I understand from Richard, there's the growing importance of IAC and the memorandum of understanding that it has with the Asian Football Confederation to resolve football disputes, the use of negotiation and mediation to resolve commercial disputes, and you gave the example of the image rights, and what a point of commonality between the general courts getting involved. Obviously the criminal law, you gave some examples around match fixing, but then there's also been the employment law, actually in both countries with disputes around the non-payment of wages. And then you highlighted towards the end the regional issues regarding stadium safety. So questions, if I can look in the chat function. If there's anyone with any questions, please feel free to unmute and put them directly to the panelists, or to write them in the chat function. If not, I have a question for our panelists. It's a very general one, and possibly a secondary one for the barristers in London. So the first general question for all of you: what are the important disputes or issues to look out for, in your view, over the next 6 months in London and in Kuala Lumpur? Who wants to take that question first?
I'm happy from a London point of view, just very quickly. I think it's quite an obvious one. But in the footballing world, I think everyone's going to be looking at a keen interest with the outcome of the ongoing dispute over the 115 charges that have been laid at the door of Manchester City Football Club. They are various, but they, broadly speaking, relate to its compliance or not with rules about profit and loss and that sort of thing, and compliance with Premier League rules around that. And people are looking at that with a keen interest because 115 is obviously a lot of charges, and the consequences for one of the biggest clubs in world football could be significant. But so we will see. But yeah, that's an obvious one, I think, from our side.
Okay, and Richard.
I think Isabel wants to ask a question, but I'll try to answer first. Rupert, you want to try to answer that first, Rupert? The general question?
Well, I mean, I agree with Michael. I mean, that is the big one. I think for those of you interested in particularly anti-doping, I obviously can't sort of go into detail, but keep an eye out, because I think there's some big cases coming up on that, which will be seen soon.
Well, I'm also looking forward to hear the results, because being an Everton fan and Everton being deducted for some very strange financial reasons, Man City getting away with 115 charges is a bit strange, if you ask me. So looking forward to hear that too. But in Malaysia, Leanne, in fact, I would say this region, the next 6 months, I think, and it's not just the next 6 months, Leanne, it's been going on for quite some time. I see a continued growth in esports disputes. There's been a trend towards leading esports towards a particular ADR mechanism. And recently, last year at the Asian Games, ASEAN Games, they had the esports game had a particular disciplinary proceeding with regards to the esports disputes. And even AIAC is also looking towards that area. And another matter is that at the end of the year, in around November, December, this region will be conducting our biennial Southeast Asian Games. We call it the SEA Games. And that is the biggest mini Olympics in this region. I foresee new issues there, because the SEA Games is continuing to evolve. Now we have ad hoc arbitration going on, etc., etc. And I believe that will be another area for us to see how the SEA Games make the arbitration system into a permanent structure into the SEA Games. I also foresee, last but not least, I also foresee anti-doping mechanisms being improved, because in Malaysia, for example, the anti-doping agency is aggressively pushing for new amendments to the law in order for them to be an independent body and regulate anti-doping. So these are what I will see within the next 6 months to 1 year in this region. In Malaysia, sorry.
Thanks, Richard. I think, Isabella, you have your hand up. If you'd like to unmute and ask the question.
Hi all, thank you so much for such a helpful and insightful talk. In terms of some of the skepticism about the government potentially getting overly involved in sports law, I wondered if the panel had any thoughts about areas where they thought it was actually useful for the legislature to be involved. And what comes to mind is in the women's football space, there was initially a loophole where police didn't have powers of arrest for pitch invaders because women's football games weren't designated matches. And the legislator basically got involved and made an football spectators prescription order that enabled police to protect women's footballs in the same way that male footballs were protected from pitch invasion. So I just thought if the panel had any other thoughts about where it could be useful for the government to get involved from a legislative angle.
Yeah, I mean, football is an obvious example, and I'm not one who is entirely skeptical about an independent football regulator. The difficulty with football, I mean, football's an interesting one because actually, if it actually dominates the sports world and arbitration world. I mean, I think I can't remember the statistic, but the majority of CAS decisions, for example, and arbitrations are about football. And the reason it's got to that position is that it is simply money, and there is a lot of money at stake in football. That it increases the desire of organisations such as the Premier League to keep control of things, because for obvious reasons. But it does mean, I think, that in areas like that, there is a strong argument for government becoming more involved, because there are other issues apart from money which can get overlooked. And you've cited one example. There's also the question of relocation of football clubs and such like. And because most of the money is coming from sponsorship and TV rights and so on, there are, as it were, issues on the ground that might affect fans who go to games and so on, which is quite proper for a public authority to become involved in.
Michael?
Thanks.
Yeah, no, I mean, Rupert's answer is very similar to the one I would give. I think, particularly again, if we're just looking purely through the telescope of regulation in football, it's yes, it is an economic powerhouse at the top end, but as you go further and further down the pyramid, you've got these sort of big community and heritage assets, which are in a lot of cases some real financial distress. And it seems to have been the case that whilst the sport has regulated itself, no one has really sort of taken their mind to whether or not, and if so, how, that structure should be addressed or repaired, because it's potentially leading to a lot of very important, sort of community clubs and community assets, being really at risk of completely going out of business altogether. So that's certainly one argument, sort of compelling argument, that's put forward for greater government oversight, because these are community sort of assets, so it's wider simply than just the sort of narrow sporting realm that we're looking at in these kind of cases.
Hi, Isabel. Can you hear me? So in Malaysia, the government does not regulate the sports per se, but instead we have a few strong parliamentary statutes which empower the government to assist sports. So, for example, the National Sports Institute Act is to regulate sports technology and sports science. I wouldn't use the word regulate in a strict sense, more like to help to operate it. And then we have the closest way of regulating is the sports commissioner, which is more towards regulating the election process and the behavior of the sports association. But the sports itself, like what's happening in UK now, the attempts to regulate football, chances are won't happen in Malaysia. So that is not happening in Malaysia yet. Thank you for the question, Isabel. Thank you. Good question.
Thank you. Any other questions? No, I think given the time, it might be time to wrap up. So I just want to conclude by thanking our panelists for a thoroughly interesting and engaging session on the current trends in sports disputes in London and also in Kuala Lumpur. And also to thank the audience for joining us today. Thank you very much and enjoy the rest of your day.
Thank you. Take care.
Thank you,
Thanks,
Leanne.
everybody.
Thank you. Thanks, everyone.
Good luck. Bye-bye.